jump to that. Yeah. All right.
Good morning, everyone. I think we'll get started. I know that the plenary session went a little longer than scheduled, and so we likewise are starting a little bit later. My name is Susan Graber, and to introduce myself, I'm a judge on the Ninth Circuit Court of Appeals based in Portland, Oregon. And as a practitioner, before I went on the bench for a number of years, I worked in the labor and employment law field and encountered arbitration every day. So that may be one of the reasons why I was asked to moderate this panel. Before we start, let me make sure, has everybody turned off your cell phones? Thank you. And I've also been asked to remind you that right after this panel at 1:15, there is a group luncheon with featured remarks by Senator Charles Schumer, which will be upstairs in the Marriott ballroom on the lobby level where the plenary session was earlier. And there are volunteers and hotel personnel that will help guide you through the labyrinth to get there. The main focus of today's discussion will be the pros and cons of mandatory arbitration, binding arbitration. But in our conversation, we hope to touch on some of the broader implications of ADR in general and other forms of ADR. Our discussion, I hope, will provide a mix of theoretical and practical comments that we hope will be both stimulating and useful to practitioners. I want to introduce briefly our panelists in the order in which they'll make their opening comments of 5 to 7 minutes each. Then I'll define a few terms. Our panelists will give you their perspectives for that few minutes. Then we'll have a conversation among us and take your questions. Moving down the line here, Justice J. Anthony Klein serves as presiding justice of the California Court of Appeal for the First Appellate District, Division II in San Francisco. He's written and lectured on ADR and will begin by presenting a provocative critique of binding and mandatory arbitration, its overuse, and some negative effects of its pervasiveness. Chris Landau, who's at the far end there, heads the appellate practice section of Kirkland & Ellis here in Washington, D.C., and is a commercial litigator. He has argued arbitration-related cases in several circuits and in the Supreme Court of the United States. Chris will discuss the history of the Federal Arbitration Act and will defend the virtues of arbitration. Sitting next to Chris is Elizabeth Cabraser, who's a founding partner of Leaf, Cabraser, Hyman, and Bernstein of San Francisco, California. She represents plaintiffs in mass tort and consumer cases primarily. And Elizabeth will discuss arbitration and ADR, particularly in the consumer class action context. Finally, Joseph Sellers is a partner in the law firm of Cohen, Milstein, Hausfeld, and Toll, again here in Washington, D.C. He heads the firm's civil rights and employment law practice. Joe will round out the discussion by exploring arbitration and ADR in the somewhat more traditional labor and employment context. So that our conversation will proceed from a common understanding, I'm going to briefly define some of the terms that you'll hear us using. Classically, ADR stands for Alternative Dispute Resolution, meaning an alternative to public trials in regular state or federal courtrooms. More recently, though, its advocates prefer that the ADR stand for Appropriate Dispute Resolution, recognizing that different kinds of disputes need and deserve different kinds of fora, including but not limited to courts. Arbitration refers specifically to an adjudicatory method of dispute resolution involving one or more neutral third parties, usually agreed to by the disputing parties, either individually or the organizations from which they come, and whose decision is normally binding. We'll also be referring to mediation, which is a kind of a conference or conversation involving a neutral third party who assists parties to settle. You may hear references to neutral case evaluation and other methods where parties are given information on how outsiders see the merits and demerits of their cases. So you may hear references to other forms of ADR, although primarily our discussion will center on arbitration. It's been around for a long time, but didn't become common or widespread until the 1960s and 1970s. Some people date the modern ADR movement from the 1976 Pound Conference on popular dissatisfaction with the administration of justice, and others refer to the community justice movement of the 1960s and 70s, individual empowerment, and other movements away from what some writers on the subject have described as the male model of combat. So with that introduction of terms and individuals, I'll turn to Justice Klein for his comments.
Well, thank you. I'm happy to be here, and I'm pleased that ACS has found this a subject worthy of discussion, because on its face it doesn't deal with the substantive issues that most people in ACS are most interested in. But as I hope I can explain, I think that ADR potentially in this country creates some ominous problems for the adjudication of public justice. I want to emphasize at the outset that the views that I'm going to express, which may, among other things, indicate that I am against settlement, should not draw that inference. Settlement is a reality in our federal and state justice systems that is simply not going to go away. Our system would collapse. Most cases should settle. Most cases do settle. Most cases will always settle. But it's the attitude about settlement that concerns me, and the implications of the elevation of settlement over adjudication that creates the problem that concerns me. But I also want to say at the outset that the views that I'm about to describe are based almost entirely on my experience in California. And I recognize, and I want to lay out on the table right now, that what's happening in California is almost certainly not what is happening in most other jurisdictions in this country. But I believe it is nevertheless important because, as in so many other areas, what happens in California tends to be a prelude to what is going to happen elsewhere in the country. There's been, I have gone through a 180-degree change in my attitude about what is generally referred to as ADR. This movement in California began in the 70s. At that time, in the late 70s, at that time, Jerry Brown was the governor, and I was his legal affairs secretary. For reasons I won't go into, Jerry Brown didn't want to create more judicial positions. California then and still is the largest judicial system in the world. It's 3 times bigger than the federal system. And so I was being attacked as the legal affairs secretary. I was the point man on this issue and had to come up with a positive explanation for the governor's refusal to create more judicial positions. And so I came up with this idea of ADR, which, as you just indicated, is an idea that was around. It came up out of the community justice system, which was significant in California, particularly in San Francisco. We didn't invent ADR, but the Brown administration in the early 70s put it on the map. And I was the architect of most of those measures, which I deeply believed in at that time. That's no longer my view. I won't say that I've created a Frankenstein, but I have created, it's a bit presumptuous of me to say that I created it. I've assisted in a movement that I now very much am growing to fear. But I'm not the only one who's moved 180 degrees on this. The courts have as well, at least the federal courts until the late 80s. In a 1953 opinion, a case called Wilco versus Swan, the United States Supreme Court probably more eloquently explained why the courts in this country, and not just federal courts, so disdained arbitration and mediation. Basically, as Wilco explained, first, the feeling on the bench then was that arbitration and mediation invariably occur between parties with unequal bargaining power, and the weaker party is ordinarily obliged to surrender rights. Secondly, that ADR, I'm using the phrase ADR, they didn't use it in 1953, is less faithful to law than adjudication, and for that reason it's increasingly used by powerful private interests to avoid law and jury verdicts. And finally, and I think perhaps most importantly, the feeling was that private dispute resolution is not a desirable form of social regulation. Now, we now have the movement that the Brown administration began, which was focused on judicial arbitration, has now moved to a different level. The form of ADR that is now the prevailing form in California, and I think probably in the entire country, is mediation, and increasingly mandatory mediation, and not just in family law cases where mandatory mediation began. Ironically, the reason for this great interest now in mediation is that a series of judicial opinions, the opinion of the United States Supreme Court in Gilmore and the California Supreme Court even more aggressively in a series of cases in attempting to help or to further arbitration, made or insulated arbitral decisions from judicial review and therefore created risks to binding arbitration that didn't previously exist, which shifted the interest of large corporate interests to mediation or mandatory mediation. But it is my view, I guess the Senator, and I guess I'll have to explain this as this panel goes on later, I believe that the ADR movement in California has presented a fundamental challenge to the integrity of the public judicial system. Now, most of the critiques of ADR, and we're going to hear about this, I'm sure, has to do with the justice or injustice of arbitral and mediative processes. And there has been a large amount of attention paid to that subject. So I'm not going to rehearse it now. I have a feeling that Elizabeth and others on this panel may be better prepared to explain that than I am. What I'm concerned about primarily is something that's received a lot less attention. That is, as I say, the effect of ADR on the judicial system. Now, the only aspect of this that's widely acknowledged, at least in California, is that many good judges are leaving the public system for the private system, where you can make $10,000 a day at the top, and double or triple or quadruple a judge's income rather easily. In the last 10 years, 5 members of the California Supreme Court have left that court to become private arbitrators. So, but this is not a secret. But there are other aspects of this that are much less appreciated, and that is not the departure of judges from the bench, but the increasing unwillingness of judges to sit in criminal departments. Now, a judicial position in California is not seen as the end of a career or the capstone of a career in the law, but just another step in a progression towards the private sector. So that being in a criminal department doesn't help you with that. In many county superior courts, finding really good judges to sit in criminal departments is not easy. But much more fundamental than that is the increasing suspicion of many lawyers, particularly plaintiffs' lawyers in civil cases, about the aspirations of sitting judges. This is hard to, the view is that a judge who is 2, 3, 4 years away from retirement and intends to join an ADR provider, of which now there are plenty in this state. I mean, ADR is now one of the largest unregulated industries in the state of California. That aspiration may affect his attitude about the cases that are being brought to him while he is sitting on the bench. Now, that's a subject that I'm happy to go into a little bit further later. But there is something else, which I think is the greatest problem of all, and that is the increasing extent to which ADR is undermining the ability of the judicial system to perform its prescriptive function, which is arguably its single most important function. And anybody can settle a case, but only a judge can adjudicate a case. And arbitral and mediated processes will not result in public decisions. You will not get Brown versus Board of Education from an arbitrator or a mediator. But the extent to which ADR is taking important cases out of the courts is diminishing the ability of courts to say what the law is. The conventional view is that arbitration and mediation takes place, to use the famous phrase of Professor Mnookin, in the shadow of the law. But the shadow of the law is getting shorter and shorter. Public construction disputes in California have basically been taken completely out of the courts. Under statutes in California, arbitrators in those cases have to decide cases according to law. The California Supreme Court and the courts of appeal haven't seen these cases in the last 40 years because of mandatory arbitration, not mandatory, but almost mandatory arbitration in public construction contracts. Decisions relating to the fiduciary duty of corporate directors, they're out of the courts. For a variety of reasons, ADR is seen as preferable. And so judges are not being permitted to say what the law is with respect to an increasing number of types of cases. And this is a real problem. Perhaps we can go into that too. But I want to close with this. I want to change the subject a little bit. The argument why, you might well ask, is ADR, at least as I'm saying, in California, and those from you who are from California don't need to be told this by me, why has it had this impact? Why has it grown? What is there about it? Now, the conventional view is that it is better. It is cheaper, faster, and more satisfying than going to courts. This is what ADR providers say, because they have an economic self-interest in saying this. Now, the fact is, I'm sure that we will hear this today, but I will say there is no empirical evidence that supports that proposition. Moreover, what empirical evidence exists shows exactly the opposite, at least to the extent what it shows, and I'll be happy to direct anybody who's interested to the evidence that I'm talking about, is that there is greater satisfaction with adjudication than there is with these various ADR processes. And the reasons for that are primarily because of the perceived procedural fairness, and secondly, because of the extent to which a litigant can personally be involved in the process, to have his, quote, day in court. But what's happening is that lawyers and increasingly even judges are telling parties to civil disputes that you are better off outside of the public system, which is why we have vanishing trials, or one of the reasons we don't have trials anymore in this country. If you have a trial, it used to be a trial was the thing that judges did. This was the center of our business. This is what we were there to do. Now a trial is seen as a failure. If the case doesn't settle, then the court and the lawyers have failed, and so we have to have a trial. And so attitudes about adjudication, you know, when I was in law school, but then I'm older than most people, not you, but most, that's my Yale Law School colleague, Steve Human. When we were in,
You didn't just pick out a random
no, when we were in law school, the great judge, that was Cardozo, Frankfurt, or Holmes, was the wise judge, the able writer, the insightful person. That's not true anymore. The great judge now is the one who can settle the most cases. We've moved from a fixation on adjudication, which only we can do, to case management. Case management is now the main consideration. But what I'm asking you to think about, and I'll close with this, is case management is fine, and judicial efficiency is important, but the preservation of the integrity of the system by which we make law in this country and create rights and impose duties, when that process is undermined, when it is demeaned in the eyes of not just the legal community and the judicial community, but of the public, we have a constitutional problem. And one of the unfortunate consequences of this ADR movement, I'm not suggesting that the courts are perfect. I'm not suggesting the courts are not in need of reform, but the legal community in our state, and I regret to say the judicial community as well, is now so focused on ADR that they have lost interest in reforming the public system. It's like you send your kids to private schools, you have significantly less interest in the public education. That's what's happened in our state. Most of the law reform in California came from bar associations at the state and local level. It no longer is. Well, I've got more to say on these things, but I'll close with that.
Thank you. Before we move to Chris Landau, I was reminded that if you have questions for particular panelists or for the panel in general, we hope to have time for that before the end. And so I think you have either 3x5 cards available to you or other pieces of paper. So, and the gentleman in the second row here has lots of cards. So write down your questions and he'll bring them up here. Chris?
Thanks, Judge Brewer. I suspect I'm the fall guy on this panel, or kind of the foil. I'll just get that on the table right away, because I'm generally called on in my practice to enforce, to defend arbitration agreements. And I'd really like to focus today on arbitration in particular. I think Justice Klein pointed out arbitration is one part of the broader issue, which is ADR, but certainly from a practical litigation perspective, a very common issue out there in the real world is how enforceable are arbitration agreements, and what issues are for arbitrators to decide and what issues are for courts to decide. And those issues are really leading to quite a lot of litigation now at all levels of the judiciary. I'd really like to make two key points here today, and I'm going to spoil my own punchline by making them right up front. First, I don't think that arbitration is an unvarnished good. I think that Justice Klein has already touched on some of the issues, some of the problems with arbitration. I've certainly witnessed those in my practice as well. So certainly I'm not going to sit here today and kind of give a Panglossian view that arbitration is some kind of utopian state. I think, frankly, and I think Justice Klein also kind of touched on this, the attractiveness of arbitration, or the unattractiveness, has to be assessed in relation to the court system. And I think what is frankly driving a lot of people to arbitration isn't so much the belief that arbitration is inherently so great, but a belief that the judicial system has some serious problems. And so to a large extent, I think it's really that some issues in the courts are driving people away into arbitration, as opposed to people being affirmatively drawn towards arbitration. So to some extent, I think it's hard to assess arbitration without kind of asking the question, well, as opposed to what? And I think one can recognize very candidly that arbitration has its shortcomings, but you also have to say then, well, so does litigation, and maybe part of the answer here, undoubtedly part of the answer, is in fact looking at how to maybe address those shortcomings. I think there's always going to be something of a pendulum between the judicial system and arbitration. But anyway, again, I think you can't just look at arbitration in the void. The second thing I just wanted to say, which is kind of my takeaway in kind of looking at this from 30,000 feet, is that I think now those who consider themselves legal progressives are pretty skeptical of arbitration. I think this panel probably shows that, and that's kind of my sense in the world at large, that arbitration is now seen as some kind of a device that is being deployed to deprive people of their rights, or limit people's rights, or somehow some kind of an anti-progressive kind of thing. And again, I think Justice Klein kind of touched on this to some extent. The irony really is that if you kind of look at how we got where we are today, the progressives really greased the skids in several critical junctures to encouraging arbitration and to making arbitration easier. And so I guess, particularly when you look at the Federal Arbitration Act, that statute has almost no relationship whatsoever to what courts are doing in arbitration cases. These are all purportedly statutory cases, and you look at the language of the statute. If somebody came from Mars and looked at the Federal Arbitration Act, that alien would say, "What on earth? How do you possibly get from there to here?" And I'm generally arguing in favor of arbitration, so I'm making these arguments. But honestly, for me, as somebody who tends to be a textualist and tries to be faithful to statute, it kind of gets me tied up in knots to try and say that this is in the statute, because it really isn't in the statute. But anyway, so I just wanted to kind of talk about how we got there from here. But I think there is a larger moral to the story that you need to kind of be careful of what you wish for and beware of the law of unintended consequences. Just a real quick background on arbitration law. And again, I think this is something that's already been touched on. Traditionally, there was a very strong judicial hostility to arbitration, which isn't surprising because, in a sense, arbitrators are competitors to judges. So generally, people are going to be pretty suspicious. A judge who thinks that their job is to adjudicate, to resolve disputes, is going to say, well, wait, why do you want to take that away from me and give it to somebody else? And they're going to be suspicious about that. That hostility was so great that back in the 1920s, Congress responded by enacting the Federal Arbitration Act, which is actually a fairly modest statute as they go. I mean, you can actually sit down and read it. It kind of is just a page long. And, it's very sketchy. It basically just says arbitration agreements shall be enforceable just like other contracts, and creates a mechanism for enforcing them in federal court. And really, for the following decades, it didn't really come up much. If you look in the case binders, arbitration was generally something in the labor context. Arbitrators were often not lawyers. They were people who really had a lot of expertise in labor matters, or the disputes that were subject to arbitration tended to be pretty factual, not really so much legal. I mean, there were a lot of times, construction disputes would be arbitrated, and again, labor disputes, generally collective bargaining agreements had provisions calling for arbitration, but it was somewhat limited in scope. The judicial review that was established for arbitration was pretty limited, because I think courts basically felt, look, the arbitrators have really special expertise in these areas, and so basically it doesn't make sense to kind of go through that arbitration procedure and then have extensive judicial review. So there was almost a complete hands-off judicial review. Things really started to change, as in so many other areas, in the late 60s. And I really think that the watershed case is a case called Prima Paint, which is 1967, and it's Justice Fortas. And in my view, kind of looking at the whole flow of this, that decision really kind of uncorks the bottle on the Federal Arbitration Act and says, there's a substantive federal law of arbitrability that establishes as a matter of substantive federal law, regardless of what state laws are, that a challenge to the whole underlying contract is severable from a challenge to an arbitration clause. Basically, in that case, somebody was trying to get out of arbitration by saying, oh, I was fraudulently induced into the whole contract. And, I think one way to look at this, and this is what the dissent said, is, well, that's an issue for state law, whether or not these are severable, whether or not, knocking out the whole contract would knock out the arbitration clause. And the majority of the Supreme Court in Prima Paint said, no, the Federal Arbitration Act says that as a matter of federal law, you can't avoid arbitration by challenging the underlying contract as opposed to the arbitration clause itself. Now, it's not really clear where that is in the Federal Arbitration Act. There was, kind of a sketchy textual argument there, but it was a fairly pragmatic decision, as so many decisions were in the late 60s. This was, obviously the height of the Warren Court, and I think there was a view that arbitration was a good thing, because the cases that were subject to arbitration were often kind of commercial disputes. This was not an era when you would really see, consumer disputes being subject to arbitration. I think there was a sense that, well, the federal courts, we want to spend time deciding civil rights cases and stuff like that. Let's just kind of get this stuff out of the courts. And again, I think Justice Klein really touched on this himself, that this arbitration was considered kind of a progressive thing. The case that really then built on Prima Paint was Justice Brennan's decision in the Moses Cone case in the early 80s, which, has these statements that for the first time, that's where the U.S. Supreme Court said the Federal Arbitration Act, quote, requires a liberal reading of arbitration agreements, and, quote, questions of arbitrability must be addressed with a healthy regard for the federal policy favoring arbitration. I mean, these are things that are not in the Federal Arbitration Act itself, and they subsequently got picked up. But again, I think the key point there, or an interesting point that I think gets lost nowadays, is that that's Justice Brennan talking there, okay? That's not Rehnquist, that's not, that's not some of the other folks on the court who now kind of, with the lens of 2007, one might think would be the ones to be pushing this. And then the Federal Arbitration Act is kind of like this blob that keeps expanding, and before you knew it, once you take the logic that it creates a substantive federal law of arbitrability, before you know it, the court's saying that it applies in state courts, even though, again, a clean reading of the statute is pretty clear that it's just something that applies in federal courts. And in fact, this drives the state attorneys generals absolutely bonkers. They have, in this case called Southland in the early 80s, the court held that it applied in state court. They have since asked the court repeatedly to overrule Southland, even though the court has declined several times. They keep coming at it. They're not going to let go of that Southland issue. And, it's not, Justice Thomas says, look, I'm a textualist. I agree with him. It doesn't apply in state court. So he is off in any case that comes out of state court, he won't apply the Federal Arbitration Act. But, the court has, in a number of cases, said that arbitration applies not only to kind of factual disputes, but, it presumptively applies to claims under federal statutes, like in the Mitsubishi case, they said antitrust claims. In the Rodriguez de Quijas case, they said securities claims, and they actually overruled the Wilco versus Swan case that Justice Klein mentioned earlier, and the Circuit City case, to employment discrimination cases. So now I think there's a view that arbitrators are just as able to apply the law as judges, and serious legal and statutory questions are being sent to arbitrators, which presents, and so now we're really at a point where basically anything is arbitrable, including many disputes about arbitrability, which I think drives a lot of people crazy to say, well, wait a second, my whole question is whether or not this should be arbitrable. Why are you sending me to arbitration to decide whether or not I should be in arbitration? But the court is doing that pretty consistently now. Some of the interesting issues I think that we'll get into on this panel, and hopefully have some discussion. One of the things that I think is an interesting thing to talk about is the scope of judicial review, which is kind of still the very deferential thing, which is a leftover from the days when it was very factual, the kind of stuff arbitrators were deciding. Is that appropriate now that, clean legal questions are being sent to arbitration? I think that's a very interesting question. I know Justice Breyer brought that up at the Buckeye argument in the Supreme Court a couple of years ago, which was their most recent decision. But there's other really hot-button issues that I think we're going to talk about now, about unconscionability, the ability of third parties to enforce arbitration agreements. It's certainly a hot area from a practical perspective in the law, and it's just kind of this area where you don't see people kind of playing their typical roles because the textualists are kind of not where you'd necessarily expect to find them, and people are all over the board. I will say that the one thing is that I don't think there's really any justice right now, on the Supreme Court at least, who you would say is an anti-arbitration justice. Even the more liberal justices are, nobody's leading a crusade against arbitration at the Supreme Court. And so I think, the Supreme Court is still in what I would say a very pro-arbitration mode. And I thought that actually I thought Buckeye might be which I argued up there, and we won. I thought maybe we'd lose the textualists. I thought I thought Justice Scalia may be like, whoa, this is way too crazy for me. I'm looking at the statute. I don't see what you're saying. But I think their view was, look, this ship has sailed. So anyway, I'm sorry, I probably overdone my time, but that was kind of my 2 cents.
Thank you for your 2 cents. We'll get maybe a nickel's worth out of Elizabeth next.
Well, I just want to ask, what's in your wallet? If you have a credit card, what you've probably got is a class action waiver, which sounds like a perfectly innocent sort of thing, but it is actually an agreement on your part to forswear participation in any consumer class action that anyone might bring arising out of a dispute with the company. It's an automatic opt-out of the judicial process. And at least in some courts, in some places, under some circumstances, it is enforceable. How did that happen? Why did that happen? And what, if anything, can or should be done about that? I'm not here to speak to the whole panoply of ADR mechanisms, many of which are quite valuable and have tremendous social utility. I'm focusing very narrowly on the phenomenon of mandatory arbitration in the consumer context, where pre-printed contracts and forms, what the courts sometimes call contracts of adhesion, include terms and provisions which eliminate access to the public justice system for disputes, typically small dollar value disputes, involving banks, credit card companies, computer companies, internet providers, telephone companies, etc. Just the daily grist of the consumer mill. Disputes that might add up on an individual basis to a few dollars or maybe only a few cents. The sorts of things that no reasonable person would spend their lives in formal litigation attempting to rectify, at least on an individual basis. So you might think, and it certainly would seem, at least conceptually, possibly idealistically, that this is exactly the arena in which an alternative to formal litigation would be most useful. Arbitration, for example. And I think to the extent that liberals are being blamed for arbitration, and since those of us who are liberals just tend to take on blame
We conservatives love
on
to,
a free-floating
to give it out.
basis. Okay, all right, my fault. Why? Well, it was conceived, of course, as a less expensive, quicker, less formal, more communitarian alternative to formal legal process, which over the years has tended to become expensive. People get priced out of the formal justice system. It's a public system. We're meant to have equal access, but litigation gets expensive. People get priced out. And so arbitration, like class actions or representative litigation, was seen as an alternative. Problem, over time, arbitration gets more formal. Lawyers are involved. That's probably just coincidental. But things happen. Discovery, written opinions, the American Arbitration Association, it becomes an institution that involves its own costs, delays, traditions, expertise, professional practitioners. So once again, people find themselves priced out of the system. And arbitration is inherently an individualized system, although there's the possibility for class actions within the arbitration system. You have to look very long and hard to actually find such a beast. It's not something that an arbitrator is comfortable doing, although the Supreme Court has said that arbitrators can conduct arbitrations as class actions. Typically, an arbitration is individual. The decision is private. It doesn't have precedential effect. It doesn't affect similarly situated customers or companies. And so it is much, if not all, of the expense, delay, formality of the public legal system without the benefits of that system: precedent, guidance, public adjudication of issues, and the changes in conduct that can occur as the law evolves. For those same reasons that the arbitration system has disadvantages to the average person, the consumer, it was seen to have very specific advantages to companies. It's not too cynical, I don't think, to say, and at least a law and economics person would say this, that if you see a tool that you can use as a tool of attrition that prices the other person out of the process, that exhausts them before they can get to the point of adjudication, you use it if you can. We have a legal system that's an adversary system. The system allows that to happen to some extent. Judges try to control it. Same thing happens in the arbitration system. And so we began to see in the 90s standard form contracts, the small print things you get in your billing envelopes, or perhaps you now would see if you go to that part of the website online, that not only provide for arbitration as an option, but mandate arbitration. Mandate arbitration at the cost of the person seeking arbitration. Mandate arbitration utilizing the company's arbitrator. Mandate abandonment of any sort of formal litigation process. And those are contractual provisions, at least on their face, and they are sought to be enforced in the court system. A lot has been happening in the court system about those provisions, notably the California state courts and to some extent the Ninth Circuit, because there's so much consumer activity, have looked at those provisions, particularly the class action waiver provisions and other adhesive elements, and have at times been unwilling to enforce them. There's a lot of case law out there, but just for those of you who are interested in one-stop shopping, a decision that came out just last week from the Ninth Circuit called Douglas versus Central District, with a cite of 2007 U.S. App Lexus 17061, summarizes the state of California state law, because this involved California state law, and features Judge Kaczynski taking umbrage at the thought that someone who never had notice of a contractual provision might be bound by it without notice to him. This discusses the profound issues both of procedural due process and incursions into the substantive and traditional law of contract, such that judges that you might not at first blush think of as consumer advocates nonetheless are now looking at arbitration provisions as if they were any other contracts and as if they are subject to the same procedural due process strictures. This was a case where somebody signed up for a long-distance telephone service with America Online. America Online's service got sold to someone else. That someone else decided to put in class action waivers and mandatory arbitration provisions, and the way they notified the customers was they put that agreement on the website. Well, those of you who actually passed your contracts course might not recognize that as having all the elements of a contract, and that was the same criticism that the Douglas panel waged. The Supreme Court might or might not take the same view. I think under classic contract law, justices and judges that are thought of as more traditionally conservative may have to begin to look at contracts of adhesion, arbitration contracts, the same way any other contracts would be looked at. And I think that's one way of bringing arbitration back into the realm of what we are all used to as procedural due process protections and substantive legal concepts that we think that we are all comfortable with. You know, the impetus behind arbitration was probably in large part greater fairness of the golden rule. But as my mother, who was a bit of a rabble-rouser and a cynic, used to say, remember the golden rule, then what has the gold makes the rules. And I think that's what's happened to formal arbitration in the consumer context. It's been hijacked, if you will, and used as a tool of attrition, an anti-consumerist tool. I think the courts are beginning to look at that and beginning to rectify that, at least in terms of ideas of procedural unconscionability. I see that as a positive trend, but I will warn you that it is a trend confined primarily to the West. If you want to get a sense of the law in all the circuits, the other case to look at is another recent Ninth Circuit case, which does contain somewhat of a survey of the various circuits. And that case is also a 2007 case called Sanford versus MemberWorks, 483 F. 3rd 956, involving a very interesting telemarketing script that turned into an arbitration provision that, again, the Ninth Circuit elected not to enforce.
Thank you, Elizabeth. We'll turn now to Joe Sellers, and I want to remind you again that if things have come to mind that you would like to have the panel address, write down your questions. When Joe is finished, though, I have a few to start the discussion rolling.
Thank you, Judge Graber. Probably the labor and employment area, particularly the labor area, can claim the most credit for the origin of arbitration. Those of you who may remember from labor law will recall the Steelworker Trilogy, in which the Supreme Court, in 3 cases quite some time ago, endorsed the use of arbitration in the organized labor setting in an era when organized labor was a frequent bargainer with management and when the bargaining relationship was relatively even. I think those who were advocates of arbitration then might be surprised by its application to the employment setting today. We begin with a decision which was sometime after the Steelworkers Trilogy, but still some time ago, the Alexander against Gardner-Denver decision, in which the Supreme Court said, notwithstanding the fact that we are endorsing the use of collective bargaining and arbitration as a vehicle for resolving disputes in the workplace, when the claims arise that involve statutory claims, particularly discrimination claims, the plaintiffs have the option to pursue those in court, notwithstanding that in virtually every other area of the workplace, disputes would continue to proceed to arbitration. That precedent has since been overshadowed, indeed probably overridden, by the recent decisions of the Supreme Court, which have, in the name of favoring the policy, recognizing the policy favoring the arbitrability of disputes in the Federal Arbitration Act, concluded that that employment discrimination claims are readily susceptible to arbitration, binding arbitration. And I should say that I think one of the biggest issues here is the nature of binding arbitration. I don't speak against arbitration itself, but in most cases, employees are expected to elect to, or perhaps not even elect to, assign an arbitration agreement to arbitrate all disputes arising from their workplace relationship with their employer at the time they begin their employment, at a time when most people don't focus on problems in the workplace because they don't foresee any. And then there are a great deal of litigation we've seen in the employment area is directed at whether that agreement is later enforceable, when employees may prefer to pursue their claims in court, or when they finally either read the fine print or find the fine print that they never saw before, which may impose restrictions on the way in which they can pursue their claims in arbitration. And then most courts today are concluding it's too late, that they're bound by the arbitral forum and can never proceed to pursue their claims in court at all. I want to touch on 3 areas that I think are relatively unique to the employment relationship that probably fall into the category, at least a couple of them, of be careful what you wish for, because it may lead to consequences that neither employer nor employee may welcome. The first is that employment claims, and particularly employment discrimination claims, are typically, I think more so than most other areas of dispute that are subject to arbitration, very fact-intensive. They turn on lots of nuances and multiple witnesses who may together demonstrate, if the plaintiff's successful, that there was an intent to discriminate. And as that kind of intent is rarely reflected through direct evidence, it usually comes through circumstantial evidence. And so the access to information that an employee who wishes to pursue an employment discrimination claim must have is substantial, and the rights to discovery that are substantial and available routinely in federal courts are not necessarily equally available in arbitration. Sometimes arbitration agreements purport to limit those rights to discovery in the fine print. Sometimes they're silent and the rights to discovery are left to the arbitrator, which is, I think, more often the case. And then the employees have to battle over what discovery is permissible, particularly as the employer typically has superior knowledge about the incidents that are at issue than the employee. and therefore it may not have any interest in the discovery agreeing to the discovery that the employee needs. So there have been a good deal of litigation over whether or not restrictions on discovery in employment, in arbitration agreements and employment settings are permissible, or whether they render either the arbitration agreement in its entirety unenforceable, or they are excised as severable and unenforceable terms of an arbitration agreement. Clearly, I think it's the case that if an arbitration agreement provides you may not pursue discovery at all, those are generally not enforceable. That shouldn't be hard to figure out. Where the battleground lies is when there's some kind of restriction, no more than 3 depositions per side or things of that sort. Whether that's a ground on which that's going to so impair an employee's ability to enforce his or her rights as to make that term or the agreement itself unenforceable. Courts are divided over that, and it is unfortunately the subject of a lot of litigation and somewhat unpredictable as to how that's going to proceed. And certainly it's even more unpredictable as to what arbitrators will permit in those settings if the agreement is silent. That's one area that is a hot area. Second is unique, I think relatively unique to the employment setting, is arbitration agreements, of course, are contracts, and they are interpreted as contracts, and their enforceability is interpreted as contract, typically under state contract law. Employees who are asked to or expected to sign arbitration agreements continue to have an ongoing relationship with their employer. And when the employer or the employee act in ways, particularly the employer acts in ways which may be inconsistent with the notion that that agreement is enforceable and binding, the employer may find, when it eventually wishes to seek to enforce the arbitration agreement, when a dispute arises, that some of its conduct in the course of the employment relationship has undermined the conclusion that the parties intended the agreement to be binding. Some examples are situations where an employer has an employee handbook, which it gives to all employees and sets forth the terms of the employment relationship. And perhaps the agreement to arbitrate is in the handbook, but the handbook has a disclaimer, as many do now, that says this doesn't bind us, says the employer. We're free to change this in some way. And that has led courts to conclude if that's what the arbitration agreement is intended to say, then you can't very well expect the parties to have expected the arbitration agreement to be enforceable. Other examples are situations where employees have asked human resource professionals or vice presidents or others about this arbitration agreement that they see as they've just signed. What does it mean? And the person says, I don't really know. I don't understand it. And courts have held that that likewise means that the employer couldn't very well have expected to bind the employee to a term of an employment relationship that the employer can't even explain. So the ongoing nature of the relationship in employment may in some ways create unintended consequences for employers when they seek later to enforce employment agreements. And finally, the last, and I'll end with this, is perhaps the most extraordinary, I think, is the Supreme Court in a case called EEOC Waffle House in 2002 held, not surprisingly, that because the EEOC, which as you know is the federal agency primarily charged with enforcing and administering and interpreting the most of the federal employment discrimination laws, that because it is not a party to arbitration agreements, it's not bound by them. So it may proceed to pursue claims on behalf of individuals who file charges with the EEOC of employment discrimination and pursue those claims on behalf of the United States, seeking relief for these individuals in federal court, while the individuals charging parties may be relegated to arbitration. Now that may have advantages and disadvantages for the employee if the arbitration is truly speedy, inexpensive, and available, but it may lead to some unusual consequences that we're only beginning to see litigated. For instance, the commission, the EEOC, may pursue claims in federal court, and the employees may pursue claims in arbitration simultaneously, the same claims. And it's not clear, other than concluding that you can't double recover for the damages or the lost earnings, you may receive inconsistent rulings. You may find that one person in one forum is interpreting the law differently than the other. And I think employers may rue the day that they they require employees to proceed with arbitration rather than allowing them to intervene in proceedings that the EEOC chooses to bring. So this is an area where I think while it had some storied origins with the bargain in the workplace where bargaining interests were similar, I think the consequences today are not necessarily perhaps what many employers wish they were.
Thank you. I want to hone in on one of the issues that has been brought up here. Chris, primarily Elizabeth and Joe have gone after the somewhat easier target of the situation in which there is unequal bargaining power between the parties to an arbitration agreement. But I want to try to focus in on some of the more generic issues that Justice Klein was addressing by positing a hypothetical that involves equal bargaining power so that we can take away that variable which seems to drive a lot of the comments. Between my house and my neighbor's house, there's a very large Douglas fir tree. It happens to have its roots on his side, but it leans onto our side. And periodically, we go over and we talk to him about trimming the tree and who will pay for it and so forth, so it doesn't fall on our house. Let's assume that we can't agree on who's going to pay for it, or even on whether we ought to be able to hire the tree service so we don't lose part of our roof. At that point, although courts exist to resolve disputes, it doesn't necessarily follow that a dispute like that belongs to the courts unless the parties choose to take it there. Even if there's no precedent in our state about how neighbors should resolve disputes or who has to pay for something that's on the property line, even if there's a judge eager to write precedential opinions on that topic, if we settle it between ourselves, terrific. And if we hire a third party to listen to our side of the story and decide for us, what's wrong with that?
Nothing. As I said at the outset, I'm not against settlement. I mean, it would be insane to be against settlement. All the various forms of dispute resolution that ADR embodies are salutarily applied to an awful lot of disputes. My concern, maybe I'm alone on the panel on this, is not the injustice of the arbitral and mediative process. That is a concern. A lot has been written about that. That's important. That's just not my main concern. My main concern is the extent to which ADR is demeaning the adjudicative process. And let me give you an example.
But why is that demeaning if the parties in fact have equal bargaining power and in fact have agreed to a different form of dispute resolution? Why is that demeaning?
No, that's not what's demeaning. Let me give you not a hypothetical, a real case where there is equal bargaining power. George Neary is a farmer in the San Joaquin Valley of California. He wakes up one morning and his cows are all dead, and he has a lot of them. He calls the veterinarians from UC Davis to come and find out why. He thinks it's because he was required to dip these cattle in toxaphene. The vets come, they look at his cattle, they go back to Sacramento, they hold a press conference. This is a big issue in Central California. And he says, no, it wasn't toxaphene. George Neary's an incompetent farmer, dairyman. Neary sues these vets in the University of California. Case goes to trial. Trial takes 4 months. George Neary wins a defamation suit for $11 million. The University of California wants to settle the case. They offer Neary $7 million, and he accepts. However, this settlement doesn't happen unless the vets, who were nominal parties, although they didn't pay for this litigation, the university did, they refused to sign the settlement agreement. They said that jury was wrong. We didn't defame this guy. We told the truth, and we're offended, so we're not going to sign the settlement. So finally, the parties all come up and they say, all right, I'll tell you what we'll do. We'll stipulate to a reversal of the verdict. and then they come to the Court of Appeal, my Court of Appeal, and I'm the presiding justice, and they present a motion for stipulated reversal. And with a unanimous panel behind me, I say no. The verdict of a jury or the judgment of a court is not a commodity that can be bought and sold. This trial lasted 4 months, 12 jurors, 6 alternates, clerks, bailiffs, taxpayers paid a lot of money for this. Now, if you want to dismiss the appeal, I'll sign that. You don't have to, you can settle. You can take the $7 million. We don't want to interfere in the settlement. But what we are not going to say, without a showing of legal error, there's no claim that that verdict was factually unjustified or the judgment was legally erroneous. We're not going to reverse a judgment because somebody's paid for it. So we denied it. But we got reversed by the California Supreme Court. And what we said in our opinion was that permitting this would undermine the integrity of judicial institutions. This is what the California Supreme Court said, just a sentence. The Court of Appeals' concern for the integrity of trial court judgments is flawed. The notion that such judgments is a statement of legal truth, that's what I said, places too much emphasis on the result of litigation rather than its purpose. And then this sentence. The paramount purpose of litigation is to resolve disputes. I believe that's a very, very superficial, wrong, and dangerous statement. And I'm going to answer it by 4 sentences from a Yale Law School professor, Owen Fiss. This is what he says. And I quote, this is all a quote. Adjudication uses public resources and employs not strangers chosen by the parties, but public officials chosen by a process in which the public participates. These officials, like members of the legislative and executive branches, possess a power that has been defined and conferred by public law, not by private agreement. Their job is not to maximize the ends of private parties, nor simply to secure the peace, but to explicate and give force to the values embodied in authoritative texts, such as the Constitution and statutes, to interpret those values and to bring reality into accord with them. This duty is not discharged when the parties settle.
Justice Klein's comments referring to the Owen Fiss article and values brings me to one of the things that I was thinking about in getting ready for this panel discussion, and that is between those who defend the virtues of arbitration and those who criticize it, do you share the same core values and simply feel that they are expressed in different ways or that they're weighed differently? Or do you actually have different underlying values? And let me suggest 7 that come to mind, both in my own mind and also from the reading that I've done, as to some of the possible values that are served. First, the timeliness of a decision, neither too soon nor too late. Second, access to a decision, that is the quantity of available decision makers. Third, the costs, both financial and emotional, versus the benefits of the eventual result or resolution. Fourth, customer satisfaction, by which I refer primarily to the clients, not the lawyers, but lawyers matter too as a different kind of consumer of the justice system. Fifth, the fairness and the quality of the decision-making or the result. Sixth, upholding the rule of law in general, that is, applying legal principles. And seventh, encouraging public respect for the law and understanding of the law. Do we all share those values? I'm going to start at the other end. And if not, are we just weighing them differently or assessing differently how the use or avoidance of mandatory arbitration affects those values? Chris, why don't we start down at your end?
I think this is a great question and a great kind of insight into this, in the sense, going back to your hypothetical a second, I think that, to me, that underscores the fact that it's not really a one-size-fits-all kind of issue, and there's some disputes that are more suitable for this, and I think these kind of variables that you just set forth are kind of the variables that may lead folks in different cases to think that arbitration is more or less valuable. I mean, I would think in your tree hypothetical, that would strike me that, I don't want to be presumptuous, but I would think most of us would think that, yeah, that would be kind of odd to make that a big court case about that if you can just resolve your dispute with your neighbors. The more low-key, the better, I would think. But, I mean, you have a number of values here, and I think those sound to me like the kind of issues that you should, that are all relevant.
What about the question of unequal bargaining power? Is that the tipping point for you as to whether it's an appropriate resolution or not?
I think that's an important consideration. I think, again, I don't think this is necessarily a black and white issue, and I think that's a fair thing for folks to look at. I think the extent to which you get concerned about bargaining power is probably to some extent influenced by how much you think somebody is giving up by arbitration. In other words, if you really thought that basically, arbitration and courts were kind of separate but equal kind of things, like it was just a different forum for resolving your disputes, but you weren't really giving up anything substantive, I think you're probably less concerned about issues like that. It's where you start to think that somebody's actually giving up something valuable, I think, that people are more concerned about, well, was this really fair, the way in which you gave it up, and did you willingly decide to do it? And I think, again, there are certainly, I think, Elizabeth pointed out some very specific abuses of this, and I think clearly any kind of thing like arbitration can be abused. But I think you're kind of getting to maybe a broader, more theoretical question, which is even putting aside the abuses, like, is this something that we should be concerned about, kind of independent of the abuses? And I tend to think no, and I tend to think that, again, the bargaining power, I'm less concerned about that if I really feel like the arbitration is a fair process. I mean, to me, it's kind of like the same dispute about, are you in federal court or state court? I mean, presumably, you should be, you should have a system that gives you a fair result. This is a different forum for resolving the dispute. As long as that is a fair forum, it shouldn't make that much ultimate difference, I guess. And there are certainly reasons that it might. And those can be isolated to get away from, the ultimate issue that you're raising here about whether arbitration is a good thing.
Elizabeth?
I think all of these values, which I would almost assume that everyone would share, are best protected by a system that has options, which include formal litigation, various forms of ADR. I think the moment that you mandate a private system beyond public accountability, you have deserved some of these values, and you've possibly, given in a particular case, jeopardized all of them. And just let me give you two very specific examples of that. The first is in the area of small claims, where one might think it's least important to have access to a formal system. But in the case I cited, the Sanford case, Ninth Circuit case, woman thinks she's buying a fitness tape by phone. Okay, we've all made that mistake. Turns out,
the phone or the fitness tape?
Well, it's a bad combination, as it turned out, because she ended up getting billed $72 a year for membership in some discount service. It was billed to her credit card. She had to go to arbitration. It was mandated. She ended up being billed $21,209.28 in arbitration fees. Good news was she got her $72 back. The even better news was the Ninth Circuit refused to uphold mandatory arbitration. But that's what happens when you foreclose that access in something that looks like a perfectly routine consumer transaction that maybe nobody ought to care about. Everybody cares about the values of proportionality, not having a day in court and not being treated fairly. The other example, I'll pile on against the California Supreme Court. This is an older decision, not the same lineup that exists today. Cruz versus Pacific Care Health Systems. I think, Justice Klein, you wrote the intermediate appellate decision there, which was reversed in part. Turns out the Supreme Court found there was no arbitration of a damages claim under the California consumer statute, but that the injunctive relief claims for disgorgement and restitution, claims we think of as sounding inherently inequity, could be arbitrated. So what do you do with a system which, through an input of arbitrary arbitration, mandatory arbitration, takes away from the public legal system the power and ability to construct equitable decrees, which we see as the essence of public law? So I think that's what the risk is. It's not that ADR cannot serve these values, but I think when you start restricting choices, when you start mandating a non-public system for certain types of disputes where you don't let people in to a public system to adjudicate what might seem like small claims but yet involve important principles, you have problems, and you may be corrupting those values.
While Joe is responding to this issue, maybe our question gatherers can bring up some questions that have been written down so that we're answering the things you actually want to know.
I would second what Elizabeth said about the importance of having a choice. There's certainly occasions, such as the one that Judge Graber mentioned, where if the parties are both free and interested in pursuing the dispute, resolution of that dispute through arbitration, I think they should have the freedom to do that. I would add, however, to the prerequisite of equal bargaining power, also equal access to the information about it. That is, one neighbor might know that the tree roots are rotten and the other might not, and that might affect dramatically the ultimate result. And without having an opportunity to do some discovery, if necessary, about that, you might compromise rights that you didn't intend to. But of the 7 factors, I think the first 4, timeliness, access to decision, costs, and consumer satisfaction, are ones that ought to be about equally served by arbitration and judicial fora. I think it doesn't mean that always happens. There are limitations that I think are in one form or another that can present problems. Courts can move very slowly with backlogs. Arbitrators can artificially limit access to information or impose costs that aren't foreseen in a way that courts publish them. Those are problems that you have to deal with. The last 3, however, fairness and quality of decision, upholding the rule of law, and respect of law, I think are ones that warrant a little more thinking, because I think if we move too readily, too far to a world of arbitration, we lose the benefits of getting published decisions from thoughtful jurists that guide everybody's decision making, or should. We lose the benefit of having public forums in which the problems that people raise are known to others and they have a chance to realize that maybe they have similar problems or they learn from those. We lose the benefit of seeing that we have instruments of government that can really resolve disputes in reasoned and thoughtful ways, and when we move all that process to arbitration. And I worry about that. In some areas, such as the tree root dispute, I'm less worried about that. But
with the Internet, is it really a worry that people won't find out about similar disputes, whether they're in arbitration or
well, a lot of them are
court?
I'm sorry. I think a lot of them have confidentiality requirements that whether the parties wish to discuss them or not, they may not be permitted to do so. At least that's, I mean, the American Arbitration Association has a confidentiality provision that is presumed unless the parties agree to something other than that, which I doubt they often do. And the other aspect of this is I think that it's important to have ultimately an evolving set of rules that by which we learn to have our behavior governed. And if we start to slip away with respect to claims that are of a more public dimension and move them into arbitration routinely, claims that involve issues that are of broader consequence, we will lose the benefit of that guidance.
Now, we don't have time probably to deal with all of the questions that we received, and some of them are longer than others, but let me start with this one. What do you feel are the potential benefits or drawbacks of pre-dispute arbitration clauses in malpractice disputes, such as those used by some HMOs like Kaiser, could an opt-in program that rewarded patients with lower copays work? I'm not familiar with those agreements, but if anyone on the panel is, maybe you could comment.
I'm somewhat familiar with them, and it has been an issue, specifically with Kaiser, because the system can be a very slow one. And I think in one case that turned into a reported decision, there was a malpractice dispute, and while the pre-filing informal program that was part of the Kaiser contract was grinding away, the claimant died, which completely changed the tenor of the dispute, quite aside from the emotional harm that was done by having delaying the resolution. The idea of paying a lower premium for opting into a program like that might have merit. Again, it's all in the details of how people understand it, whether it's something that's valuable to people, whether they want to do it. There's nothing wrong with maximizing the options that people have about resolving their disputes, and anything that's going to make a services provider more accountable to its customers, I think is a good thing. But again, what tends to happen in private programs, whether they're mandatory or voluntary, that slip away from public accountability, is the health of that process is not monitored unless and until there's some abuse or some problem or some scandal, and it's brought to the public attention and usually brought to litigation. So there's an accountability factor. Any system that's handling a large volume of disputes doesn't necessarily need to be another court system, but I think it would be important from the point of view of at least some of these values to have some degree of accountability, and maybe in the era of the Internet, that gets taken care of at least informally.
There's another question here that deals both with the issue of accountability and one that was touched on in some of the earlier remarks, and that has to do with appeals. This question recites a very frustrating experience in which an arbitrator's decision was blatantly wrong, and pursuant to the National Arbitration Forum, the lawyer filed an appeal to correct the award but didn't receive a response. What is the panel's view of the proper format and forum for appeals from arbitration awards to be able to correct blatantly incorrect awards or other errors?
Well, this is a subject I do have an opinion about. I guess
unlike the others where you have no opinion at all.
No, I'm just trying to be very magisterial. I don't know what jurisdiction that the questioner comes from, but there's no jurisdiction in the world that has insulated arbitral or ADR decisions from judicial review more assiduously than the California Supreme Court. And an opinion that Elizabeth knows very well, every California lawyer knows it, it's called Monshaush versus Healy Blaze. The court held that a arbitral decision that is legally and or factually erroneous on its face, and which also, quote, works a substantial injustice, unquote, is nevertheless not subject to judicial review. Now, in that opinion, and in another one that came down a year or two later, AMD versus Intel, in which the court held that this is a case that was in a private judge had for 5 years. You're talking about the efficiency of ADR, no trial. This is on a copyright dispute between Intel and AMD. The judge comes up with a remedy which involves copyright sharing, which is not among the remedies provided for in the provision of the contract between those two parties, which was very specific about remedies. And the California Supreme Court said, well, yeah, he went beyond the contract he was interpreting, but so long as the arbitrator's decision is, quote, rationally related to the contract, it's okay. Now, the purpose of those two opinions, the California Supreme Court thought that what it was doing was helping arbitrations by ensuring their finality. The trouble is that they so frightened the world of arbitrators and mediators, or at least the potential providers of arbitral business, that there was suddenly a shift away from arbitration, a fear of it, so that those two opinions had the opposite effect that I think was intended. But what they did was they stimulated those two opinions, ironically, while they diminished interest in arbitration, stimulated an explosion of interest in mediation and mandatory mediation. This is the ADR in California that 95%, I don't have a study, but I'll bet that 95% of the ADR in my state is mediation, increasing amounts of which are mandated in various ways, sometimes by statute.
Does anybody else have a comment on what the appropriate type or level of appellate review ought to be?
Implicit in my answer was that there ought to be more.
Joe?
I think there ought to be more as well. I think, again, looking at the factors you've listed that may bear on the appropriateness of the forum, when an arbitration decision is subject to very limited review and is given great deference, as I think is the custom and practice now, you get inevitably very varying degrees of quality. The decisions may or may not be of much quality, and there's little accountability, and I think, or transparency, and I think, therefore, there ought to be more substantial appellate review.
I agree, by the way. In fact, I had a case in the Sixth Circuit where I had the same kind of frustrating experience that the contract said the arbitrators may award these kind of remedies, no damages. It specifically said no damages. The arbitrators awarded $70 million in damages. We thought, like, if there's not a more easy case for saying they exceeded their authority, I don't know what it is. The district court rubber stamped it, went up to the Sixth Circuit, they affirmed, and, we said, like, this is an anti-arbitration decision, because who on earth is going to agree to arbitration where you do give up certain rights, like appellate review and all that? You're putting your fate in the hands of these three people, and it's not healthy to say that's unreviewable. You should be able to know when you enter into arbitration that it is, that there is going to be some degree of accountability at least. So I agree with that.
There's one very widely used type of alternative dispute resolution that does have built-in accountability to courts and a review process, and that is what's frequently used in complex litigation, including class actions, of referral of specific issues such as discovery disputes or settlement to a special master or who could be a magistrate judge or a private judge under a court order that specifies the terms and conditions of that reference and provides a very specific review procedure. This is done so that judges don't have to administer long-running complex settlements, so that judges don't have to referee ongoing discovery disputes, so that due process and accountability is built in. Everybody knows what rules apply, everybody knows what law applies, and there's no possibility that the master or the judge can make up or expand the scope of authority. And I think that needs to be said, because there are a lot of criticisms that some of us have about the process. There are also ways in which appropriately cabined it can be tremendously beneficial and cost-effective and fulfill some of these values of cost reduction, expedition, predictability, and responsiveness that everyone, I think, hoped for when each of these ADR mechanisms was developed.
My timekeeper has been quietly but insistently letting me know that we're at the end of our time, and I have not gotten to all of your questions, for which I apologize, nor all the ones that I had thought we might get to, because we have a lot to say. We appreciate your being here, and thank you to the participants, and don't forget lunch is upstairs.